There's a strong and growing sentiment that there is two-tier policing in the UK because of videos like this, which I'll play you in a minute, where somebody is just posing questions to a Palestine march and is then escorted away by the police and arrested for breach of the peace. So I thought in this video I'd explain what breach of the peace is, because it may to some extent surprise a lot of you, but it doesn't detract from why people think that there is two-tier policing. Because we also get stories like this from the Telegraph, where somebody in one of these protests was dressed up as a Holocaust concentration camp inmate, holding a sign, "We are all Palestine action," and the police completely ignored that whilst warning people waving Israeli flags that they might be arrested for breach of the peace. So I'll play this video for you now, and then I'm going to discuss with you what breach of the peace actually is. Because it might surprise you to learn that breach of the peace in and of itself is not a specified criminal offence per se, unless and until it crosses the threshold for many of the public order offences, which I've covered in other videos. But for now, just take a watch of this so that you know what it is that we're talking about. Watch this.
Excuse me. Roll call. People going to gonna go and
Now, straight away, you can see that this guy has approached the crowd to talk. Someone is obviously filming him, but someone, presumably with the crowd in the yellow jacket in the middle here, has put her phone right up in this guy's face. Now, he's quite sensibly has somewhat ignored that, but bear that in mind when you watch the rest.
against Israel. You feel that strongly? Go and fight them. We can put you on a plane, a CH-17, whatever they call it, and you can go and fight against.
And so now you can see the police have immediately come around him. Now, I'm not going to draw conclusions of fact here because it appears that he's been arrested, and so this might be a live case. And so obviously this is just general comment. But you can see that immediately the police approach this guy, and all he's doing is saying, if you feel that strongly, you can get on a plane and you can go and fight for them. So they are obviously having a huge march, rally and protest with signs that many people will find offensive, which you can see on the left-hand side of that video there. And the police obviously ignore that as well. And as a sort of counter to that protest, which this guy is perfectly entitled to do, he is making comments to the crowd. If you feel strongly about it, you can go and fight. Watch on.
Israel. How good's that? You feel so strongly, you give up your Saturday. Go and fight them. Go and fight them.
So he said, if you feel so strongly that you give up your Saturday, you can go and join them. You'll note that apart from people filming it, the guy at the back and the lady in front in the yellow jacket, apart from that, there is no reaction from this crowd whatsoever. They just practically ignore him completely. He keeps shouting in response. He's not shouting. He's talking with an elevated voice so that people can hear him. He's not aggressively shouting, in my view at least. Watch on. In fact, you might consider that what he's doing there is quite jovial because they are chanting something and he is sort of going along with it. But at the same time, he is challenging the crowd. And there he actually engaged with the police officer and said, look at the flag as well, directing the police officer's attention to something that's going on in the crowd, and the police officer completely ignored what he was pointing at. And at this point, this chap is then escorted away by the police. He has a conversation with the police, and then he's taken over here and is arrested for breach of the peace. Now, without commenting specifically on that case, because I don't know what's happened, I don't know whether it's live, generally speaking, doing things like that, challenging a crowd, is exercising the freedom of expression. Generally speaking, that is not an offence. That is not likely to be breach of the peace, with the caveat that I was not there. You watching were presumably not there, unless you were, but that'll be very few of you, I no doubt. But without being there, the caveat is, You don't really know how intense it was at that time. You don't really know how serious it was. You may not have seen everything because you don't have the full field of view from the police officer's perspective. They might have seen somebody coming through the crowd to attack this guy. We don't know. And so the court's approach to this is, well, we tend to trust the police officer's judgment because we don't know how intense it was. We don't know what the police saw. We don't know how it felt to the police. And the police can act to prevent a breach of the peace. And that is relatively settled law. Now, this goes right back to the reign of King Henry II and the King's Peace, where he expanded the King's Peace to various regions around his reign, which included the control of England, substantial parts of Wales and Ireland, power over Scotland, and indeed much of France. So he extended the King's Peace to this whole area, replacing the local rules for what there was. And it is now settled law that police officers in the office of constable can arrest or detain somebody for an actual or anticipated breach of the peace. So in just a moment, I'm going to explain what that law is and why people might be entitled to believe that there is a two-tier approach to policing breach of the peace in the UK. Back in a moment, don't go away. In other legal news, this is a really bizarre story where 8 men have been convicted on an investigation into the theft of personal details from repair garages across the UK. This resulted in officers seizing 4.5 million documents, 144,000 spreadsheets, 241,000 emails, 1.5 million images, and 83,000 other multimedia files. These 8 men have been convicted for the theft of personal information. This, as reported by the ICO, is one of the largest nuisance call cases that the ICO has ever dealt with, because many people have blamed these garages for nuisance phone calls, whereas really it was these men that have stolen that data. But some of you might think, why on earth were they collecting your personal information in the first place? Well, there's 2 reasons. One is because they sell it onto data brokers and marketers, and secondly, they want to impersonate you, or they want to sell it onto other people who impersonate you. Now, both of which you can use a service that supports my channel here called Incogni, because Incogni will contact any of these data brokers and marketers, and they will request and require, using UK and US law, that they remove all of your data from their servers. Now, if you've received lots of these junk marketing calls in the last few weeks, this will be the reason why they've been selling this on to other people, because this data is valuable. They can sell it on again and again, and you'll be sold on again and again. But if you use Incogni, you'll get access to a dashboard where they'll contact all these companies and tell them to remove your data from their servers. You can put multiple email addresses in there because that's one of the features people ask for, and then they will do all the hard work for you. They contact these companies and require that they remove your data. And of course, as a partner to my channel here, I get you a fantastic discount, which is 60% off the annual plan. Just use the code BlackBelt at the link in the description below. That is incogni.com/blackbelt. Make sure you use the code BlackBelt. You'll get your 60% off. So this is a massive success story after a 10-week trial for prosecuting these guys. But now it's your time to act. Contact Incogni to remove your data from these brokers. Now, this is generally settled law here. Now, the case of Crown and Howell of 1982, it was said as follows. And that's from this bit here. The court said, "We're emboldened to say that there is a breach of the peace whenever harm is actually done or likely to be done to a person, or in his presence to his property, or a person is in fear of being so harmed through an assault, an affray, a riot, unlawful assembly, or other disturbance." So any of those things would encompass all of those scenarios that you've just seen. Only if, and I've just zoomed in so you can see a bit clearer, only if it is for a breach of the peace when done in his presence or the reasonable apprehension of it taking place that a constable or anyone else may arrest an offender without a warrant. And so, as I mentioned before, breach of the peace is a bit of an anomaly in English law. It is not a specific criminal offence per se, unless and until it crosses the threshold for one of the public order offences, and yet it carries a power of arrest, and a person may be brought to the courts to be bound over to keep the peace. And if they breach that order, then that itself becomes a criminal offence. Now, accordingly, police officers have a duty to preserve the King's peace and corresponding statutory powers with which to do so. And these include the power of arrest or to require a person to do something or to refrain from certain conduct. These are exercisable when there is an actual breach of the peace, but it is more difficult when there's an anticipated breach of the peace. Because as you can see in that first video there wasn't really a breach of the peace because there wasn't any violence. Nobody attacked each other. The crowd pretty much ignored this guy, and he was pretty jovial with them in return. And essentially, the police escorted him away, presumably before anything happened, but that would be down to them to justify. Now, as I say, the difficult question then becomes is to what can the police actually do in the anticipated breach of the peace? When can they act? What can they do? And against whom can they exercise those powers, etc.? Now, one such example came to court in Duncan and Jones in 1936. And that is when there was a proposed meeting outside a training centre. Police officers took the view that if they did that, then breach of the peace would occur. So they required to hold the meeting elsewhere. But the lady refused to do so and was arrested. She was charged with obstructing the police officer in the execution of his duty, on the basis that her refusal to obey the orders of the officer. The conviction was upheld, and the judge said that it does not require authority to emphasize the statement that it is the duty of the police officer to prevent apprehended breaches of the peace. It was found that the fact that the respondent, the police officer, reasonably apprehended a breach of the peace, and it then became the duty to prevent anything that in his view would cause a breach of that peace. In a similar situation, in the case of Moss and McLachlan of 1985, this was to do with miners' strikes. Again, the police apprehended a breach of the peace, and thus stopped cars carrying people that appeared to be miners to persuade them to turn around and not to proceed to the pit in question. And again, it should be noted that the conduct was lawful up until the point that they disobeyed the officer's instructions. This conviction was upheld at the divisional court on the ground that there was a sufficient apprehension and a real possibility of breach of the peace. I'll come back to this two-tier bit in just a moment, but just bear with me on this. In this case, the court said, providing the police honestly and reasonably form the opinion that there is a real risk of breach of the peace in the sense that it is in close proximity both in time and place, then the conditions exist for reasonably preventative action, including, if necessary, the measures taken in this case, which was the arrest of the people. Now, again, the court said that this is a sliding scale of approach. Now, the emphasis here is that the officers have to act honestly and on reasonable grounds in their view that the breach of the peace is imminent, depending on the person's role within it, and depending on the timing and the location, and that the courts are generally reluctant to interfere with the judgment of the officers who are on the spot. And the court, in another case, said the court cannot tell the police how and when their powers should be exercised, for the court cannot judge the explosiveness of the situation or deal with the individual problems that arise, because again, obviously, they are not there. But now what's really interesting, before I come back to the two-tier element, I promise, is the fact that the use of these powers with regard to breach of the peace should be used considering Article 10 rights, the freedom of expression. And of course, Article 11, the right to the freedom of assembly, and so on and so forth. And so the courts have considered whether the police exercising these powers is in breach of those rights. For example, in another case, the claimant was a passenger on one of a number of coaches travelling from London to an airbase, RAF Fairford, in Gloucestershire. She was going there with others to protest about the Iraq War. This was back in 2006, this case. The airbase had been chosen because the US bomber planes were stationed there. There'd been previous incidents at or around RAF Fairford, and the chief constable believed that there's likely breach of the peace at the proposed demonstration. Using powers under Section 60 of the Criminal Justice and Public Order Act, he ordered officers to intercept coaches, conduct a search that they believed might have items that were going to be used in the demonstration. The coaches were stopped by police some 3 miles from the airbase. They searched the coaches, they searched the passengers, and all the passengers were ordered back onto the coaches and escorted back to London. The claimant in this case brought challenges of those decisions, alleging that this action was illegal and infringed their rights under Article 10, freedom of expression, and Article 11, the right to the freedom of assembly. And the House of Lords then held that the police had acted unlawfully, in that there was the imminent breach of the peace was required before any police could take any justified action on a sliding scale. Now, comparing it with this situation here, we obviously, taking all that into account, obviously we were not there. We don't know exactly what it felt like at the time. We didn't see what the police might have seen, but only from what we can see, it doesn't appear that there's any immediate unlawful violence there. But again, we don't know what the police saw, if anything. But If we're being uncharitable, it looks like the police are not particularly interested in what's going on in the crowd, because none of them are looking at the crowd apart from the guy in the very, very background over there, if that is a police officer. They are only really focused on this guy and right up until the point that they take him away. So, save for the fact that I'm not going to draw conclusions on this case, because I don't know if it's still live or not, because it appears to have just happened recently. Aside from all that, generally speaking, the police would have to form the view that there was an imminent threat of the breach of peace, either by this guy or from anybody else. It doesn't have to be from him. It could be from anybody else. Now, on that basis, you might then say, well, that was reasonable. They were preventing it from happening. We can't really judge. The courts generally will be slow to interfere with the officer's judgment. So that might well be that. But that is where we come back to things like this, because this is quite likely to provoke a response from many people. And if the police ignore this and at the same time warn people waving an Israeli flag, which I understand that that's what happened, that is quite clearly a two-tier system. If the police are warning people waving an Israeli flag that they are the ones risking a breach of the peace and that they will be arrested, and ignoring someone wearing a hugely and obviously provocative outfit here, I can quite understand why people would complain that this is a two-tier policing approach to these protests. It should be equal and fair. And as Ant Middleton points out here, the real victims of these constant protests are not the activists there. They are the people who are paying business rates, they are business owners, they are residents, that the people who are forced to endure this. They are people of various faith, particularly Jewish, given the nature of these protests, that are in fear of their lives, even walking past or walking by, and particularly if they are warned by police or if they are escorted away. I remember one video where somebody was escorted a different direction. He was blocked from going through because the police, again, they said anticipated a breach of the peace, not because of him, but because of the crowd, and they didn't want him to walk through the crowd. Well, to put it bluntly, that's not fair. That's just a wrong approach to prevent somebody from walking through because they are unable to control the crowd. If they have a reasonable apprehension that the crowd is going to act towards him, they should be policing the crowd just as much as anybody trying to walk through it. That is a perfectly reasonable and objective statement to make. Now, as Ant Middleton here points out, the courts are underfunded, the prisons are overstretched. He says, let's stop rewarding disruption with media attention and start hitting the offenders where it hurts, fines, detention centres and deportation where applicable. Londoners deserve better. And I absolutely agree. And on the principle of prisons and courts, I can tell you that as of the recent numbers that I saw, there are fewer than 1,000 places available in the prison systems. And that's one of the reasons that they are letting people out early, including rapists and all sorts of other violent offenders are being released early. Just recently, there was a story of 6 of the most serious rape gang members released early. Now, as someone else commented on X, or opined on X, anybody that is convicted of such an offence should serve the full sentence, should not be released out early at all. And I frankly agree with that. Let me know in the comments what you think. But with fewer than 1,000 places resulting people being released from prison, we have more than 70,000 cases in the Crown Court backlog. There are over 10,000 foreign nationals in our prison system at the moment. And when we look at the civil courts, if somebody wanted to bring a civil claim, the reason that our courts are underfunded and that the system is slow and clunky. And in theory, whilst I would love to say that we have a great system and eventually we see justice prevail, we see fairness and so on, I have personally seen cases where someone has been the victim of fraud, they've been the victim of fraudulent behaviour by companies, fraud by other people, they've lost vehicles, they've lost money, they've lost houses in some sense, and it takes them many, many years to get anything back. One lady was the victim of fraud and she ended up on the fraud database and she lost her bank account. She couldn't have a mobile phone. She couldn't get a credit card. She couldn't even get a utility account in her name because she was on the fraud database. All because she sold something to someone who was a fraudster who was then reported as fraud and she was caught up in it and she ended up on the fraud database and the banks ignored my letters. I sent them letter after letter. They just ignored them. And if you wanted to proceed to court on anything like this, there are something like 1.5 to 2 million civil cases in the county court filed every year. There are hundreds of thousands of cases destined for the High Court. There are thousands of cases for the Court of Appeal. And if we come back to the criminal courts for a moment, there are something like 300,000 or 400,000 cases a year. This is going to the Magistrates Court, and as I mentioned, the Crown Court has got record backlogs of over 70,000 cases. So this is why the system is slow. Even in my case that I mentioned recently, where I was sued in the High Court, the application just for the other side to shut the case down, give up, and not proceed against me took between October in 2024 and the 6th of June to get a hearing at the High Court just for them to discontinue the case. That's how long that took. And that is just them giving up the case. That is not going for trial or anything else. So these take an awfully long time to actually get justice and actually follow these things through. On that basis, you might say, well, the police might be better just dealing with something on the spot to stop it from happening so that it doesn't find its way into the justice system. That's fair enough. But if they do that, they should be doing it fairly. Because if we get people dressing up like this, deliberately, provocatively to annoy people and to spark a reaction, regardless of your views and which side of this debate you support, and I'm not telling you which side of the debate to support. As I've said previously in other videos, I'm well aware of what's going on around in the world, and I think a lot of it is utterly grotesque. Regardless of what side of that debate you support, the police, you should at least agree, the police should be approaching these things fairly and equally robustly on both sides. And I can quite understand the people that think that that's not happening. So I hope that's a useful overview of breach of the peace and what it is, what it's not, when it should and should not be used. And if you are detained unlawfully, there are obviously civil parallel claims you can run. But let me know what you think in the comments below. And as always, thank you for watching.